3 children, 1 drainage ditch. Break time equals 600 men's. Macy arose, 9,993. 3 teenagers blamed. 0 physical evidence linked them. One would spend 18 years awaiting execution. The Midnight Paradigm. In 2007, a single human hair changed everything. It did not belong to any convicted man. It belonged to a man never charged. This is the forensic record Arkansas chose to ignore. We are not here to retell the crime. We are here to follow the evidence. On June 3, 1993, Jessie Misskelley sat down. He was 17. His IQ was 67. He waived his Miranda rights. No attorney was present. Investigators questioned him for approximately 12 hours. The recording device was activated near the end. The first 9+ hours went entirely undocumented. When the tape began, Misskelley described a murder. He placed it at noon. Victims were in school. He described a rope. Police found shoelaces. Every significant detail contradicted the crime scene. Prosecutors used it anyway, as primary evidence. What drove that decision? We examined the record. West Memphis had no homicide-trained investigators whatsoever. The case landed on a department with no forensic protocol. Jerry Driver had already decided who did this. Driver had been surveilling Echols for months prior. The framework was satanic ritual. No evidence supported it. Salem's moral panic returned to America in 1980. By 1994, the diagnosis was already discredited in psychology. The prosecution built its case on a theory, not evidence. In March 1994, the jury convicted all 3. Echols received the death penalty. Baldwin, life. Misskelley was tried separately. He was also convicted. The investigative failures were systemic, not accidental. No murder weapon was ever found, not once. No entomology study was conducted to fix time of death. No luminol testing was done at the crime scene. The prosecution's wound expert had a mail-order doctorate. Dr. James Griffiths testified the injuries were ritualistic. That testimony would not survive peer review. The defense attorney's performance was later questioned. Val Price filed no pretrial motions on key evidence. The bite mark evidence was introduced without challenge. Post-conviction review found those marks were animal bites. Turtles and crayfish in the drainage ditch. Post-mortem. Dr. Werner Spitz reached this conclusion in 2007. Spitz had performed tens of thousands of autopsies. His finding dismantled the prosecution's foundational claim. We asked, what is left of the prosecution's theory now? The answer, a coerced confession, nothing else. 13 years. That confession kept Echols condemned. Then, in 2007, Peter Jackson made a phone call. Jackson had seen Paradise Lost. He had questions. He funded DNA testing through Bode Technology. The methodology, Arkansas Act 1780 post-conviction petition. Investigators collected biological samples from the ligatures. They also sampled from the victims and the defendants. The lab ran mitochondrial DNA analysis on recovered hairs. Mitochondrial DNA traces the maternal lineage specifically. In 2007, Dr. Thomas Fedor delivered his findings. 0. No WWM3 DNA anywhere at the crime scene. A generation later, the science finally had the tools. The forensic gap directly produced this wrongful conviction. Between 1989 and 2024, 375 DNA exonerations documented. In 69% of those cases, eyewitness or confession evidence. The pattern is documented. The system produced it. You think you know? Drop your theory below. The DNA result was only the first finding. One hair did not belong to the defendants. It was found wrapped in the ligature binding a victim. Now the question changes completely. Whose hair was it? The hair was consistent with Terry Hobbs. Hobbs was the stepfather of victim Steve Branch. A second hair was consistent with David Jacoby. Jacoby was Hobbs's closest friend, present that evening. Neither man was ever formally investigated by Arkansas. What did 14-year-old DNA evidence actually show? Zero genetic material from any convicted man. Hobbs's hair on the knot that bound a victim. Jacoby's hair recovered from the same crime scene. Arkansas reviewed the findings and did nothing. The state's position, the Alford pleas, closed the matter. Terry Hobbs filed a defamation suit in 2013. The suit named those who publicly identified him. He later dropped the suit. The DNA evidence remained. Let's be precise about what the DNA evidence shows. Mitochondrial DNA is not a fingerprint match. It excludes defendants. It doesn't convict Hobbs. The honest epistemic position is this: we don't know. Any narrator who fills that silence is misleading you. But we can say the prosecution's case is hollow. Now the Alford plea. This is where law becomes strange. An Alford plea allows a guilty plea without an admission. Prosecutors offered it to avoid a retrial. They faced new DNA evidence, a new evidentiary hearing. Retrying Echols with death off the table was their condition. Echols, Baldwin, and Misskelley consulted their attorneys. Baldwin initially refused. He wanted full exoneration. Echols persuaded him. The alternative was continued death row. On August 19, 2011, all three entered Alford pleas. They walked out of court. 18 years. Done. Jason Baldwin became an attorney. He defends the wrongly convicted. Damien Echols writes, speaks, practices Japanese calligraphy. Jessie Misskelley keeps a lower profile. He was 17. 3 children were murdered in 1993. This is still true. Their families deserved an honest, complete investigation. The case was not investigated honestly in 1993. It has not been reinvestigated honestly since. The question lingers: whose case was this really? Modern forensic tools exist. No one has applied them here. Phase 4 demands more than Phase 3 revealed. Phase 4 begins with an uncomfortable question. What does closing a case without solving it mean? In criminal justice, closing and solving are not synonyms. The West Memphis case is officially cleared. The homicide stands. The Innocence Project documented the systemic causes. False confessions appear in roughly 25% of DNA exonerations. Cognitive vulnerability and interrogation pressure produce them. How do you plead guilty to something you didn't do? The Alford plea, guilty on record, innocent in fact. 18 years, one of them on death row. Freed, but the murders remain officially unsolved. Arkansas closed the case. The evidence did not. This is the framework the justice system prefers. Efficient case clearance chosen over persistent truth-seeking. This is not unique to Arkansas. It is a pattern. The journalism standard, name what the evidence shows. The evidence shows 3 men did not commit this crime. The evidence also shows someone's DNA was at the scene. The evidence does not show who killed those 3 children. That distinction is where honest journalism must stand. Here is the deeper engagement this case demands. Every conviction rests on a foundation. Test the foundation. The foundation here was a confession without physical corroboration. Every state now has post-conviction DNA testing access. That framework came in part from cases like this one. The wrongly convicted paid the price for that legislation. Jason Baldwin is now a practicing attorney in Seattle. Exoneration is not freedom, a different cage. Damien Echols has said the same in different language. The re-entry literature documents this outcome consistently. Wrongful conviction leaves lasting cognitive and social damage. Our children may never know 18 years cost. The unfinished business of this case is moral, not forensic. Arkansas has the evidence. Arkansas has the technology. Arkansas lacks the political will to look. The victims' families have called for reinvestigation. Their formal reinvestigation request remains unanswered today. Somewhere, someone knows what happened in that drainage ditch. The 1993 shadow was not lifted, just moved. Full case file pinned in the comments.